Welcome back to the PI show. Before the break, we were talking about a High Court case, Brodie, and about the law really affecting councils and
highway authorities.
Highway authorities, people who, footpaths and slips and trips. And unfortunately, it's a pretty tough area of law to litigate in at the moment. But getting back to public liability, what's called occupier, someone who owns property.
Yes.
And if someone is invited onto the property, it's got to be in a safe system. And the case we're going to discuss is Helen Jones sued her friend Sharon White. Sharon lived in Wangaratta.
That's right.
And Helen was visiting her friend. She arrived at a friend's property on a motorbike. She was a passenger. And her story is that when she went into the driveway, she got off the bike and tripped and stumbled on a pothole and injured her right ankle and left wrist.
That's right.
Now, the driveway was compared to an Iraqi war zone. So there was lots of potholes and it was in a state of disrepair.
Very dramatic distinction.
Yeah. Well, the biggest debate about this case was how did she fall? Did she fall because of the pothole? Or
there were two different versions of events about how the
accident
accident actually occurred.
That's right. The solicitors for the defendant argued that the plaintiff, when Mrs. White got off the motorbike, she wasn't looking where she was getting off, and that she actually didn't look out for her own safety and fell because of that, rather than because she fell in a pothole.
Yeah. So there's two different versions, and there was a credibility issue about who was to be believed.
Well, during the case, there was a lot of there was a big attack on her credibility and credit because they were trying to show her to be a poor witness or historian.
Yeah.
But the judge said that she was a credible witness, which was pretty important. But there was an independent witness that really helped the situation.
Well, I think the independent witness said the driveway was in a state of disrepair, and
the words he used was it was pretty crappy.
Yeah. So it was a bad driveway, and then so I think the judge did accept her version. She fell in a pothole.
Yes.
And what's the law? I mean, so what?
Well, Harry, Section 14B of the Wrongs Act says that occupiers of premises, which includes private occupiers such as homeowners, need to make sure they have a safe premises, so when people enter on that premises, if they're visitors or otherwise, they need to be kept safe. And the court found that Mrs. White was under a duty to make sure her driveway was safe, and when Mrs. Jones got off the motorbike, the first thing she did was fall over because the driveway was in such a bad state.
So the judge sort of applied the law, if you like. And what happened to damages? What happened?
The judge made quite a generous award of damages. The judge awarded around about $95,000 for pain and suffering damages, and also awarded some damages for home help and damages for loss of earnings.
So Helen Jones ran a business with her husband up in Ballina.
She did.
And it was a roof restoration business, but on the side they ran a tattoo parlour as well.
They were quite entrepreneurs, yes.
Yes, so we assume Helen might have been covered in tattoos.
We do assume that, although we don't have any photographs.
No.
But I mean, it wouldn't have been, seriously, this case here, the occupier could have easily just poured some concrete or put some bitumen down
or just some dirt
levelled it up,
and covered the. So it was in Wangaratta. It was sort of really in a state of significant disrepair.
Well, there was between 3 to 15 potholes, so it's pretty damning, you'd think.
So
it's not one pothole. There's anything up to 15.
15 potholes, and as I say, the judge, interestingly enough, she gave different versions of events to different doctors, but I think the judge didn't take that
not into too much account. There was an issue raised by the defendants about the medical reports and how they didn't really add up as to the plaintiff's history, but in the end the judge disregarded that, as he found that it was a matter of the standard of care. It's a high standard of care for an occupier. Occupiers are expected to keep very safe premises, but at the end of the day, he found that because Mrs. Jones was getting off the motorbike, she couldn't really be making sure she was avoiding all of the potholes in the driveway.
Yeah.
And plus they varied in dimensions. Some were deeper, some were shallow, some were wide. You know,
But and the one she fell in, again there was a sort of dispute, but the judge did accept she fell in the pothole and right ankle, non-dominant hand. I think $95,000 for pain and suffering, and something for loss of income, and they had to they had to hire substitute labour.
Yeah, I think there was 20,000 or something along those lines.
And the judge awarded that as part of the cost.
There was damages allowed for that.
And I think they were on their way to Tasmania, didn't allow the Tasmanian trip, unfortunately.
No, unfortunately, they had to postpone the trip around Tasmania on the motorbikes, but perhaps next time.
Next time they'll have a more enjoyable trip.
Harry Davies.
The next case is a case in New South Wales where the plaintiff entered a hotel. I think started there about between 2 and 3 o'clock in the afternoon, and 10 o'clock, around about 9:30, it was his first trip to the bathroom. So
I think it was a big day, Harry.
It was a big day.
Yes, it was.
First trip to the bathroom, he slipped and fell inside the bathroom where there was quite a amount of water on the
That's right.
on the floor.
Right.
I just can't stop laughing when I read this case, Harry, because I mean the colourful language describing the state of the premises was just unbelievable.
That's right.
This place.
But
is
at the
really,
end of the day, it was a very interesting case because the hotel actually had a sign up outside the bathroom saying, "There's water on the floor, be careful, don't slip." And the court found that it wasn't in a prominent enough position given the amount of water on the floor.
Yeah,
Well, I think
so
what's
they did take some remedial action. I think this case could have gone either way.
Yes,
oh,
could
I'm
have
not
gone
sure. I mean, it wasn't just a little leak.
No, it was a lot of water on the floor.
The place was in really, it was underwater.
It was a hazardous conditions.
Yeah.
Yes, that's right.
And also the court said in the case that what they should have done was repair the leak, or if anything, close the toilets and get them to go to the bistro toilets.
Yeah, that would have been a more sensible alternative. I agree with that.
There were simple steps that they could have taken.
But he, as I say, he sued the hotel.
That's
he
right.
succeeded.
That's
I think he got the total water damage was about $317,000.
That's right, Harry, but I believe there was some discount because Mr. Davies had been drinking all afternoon. There was an argument to say that he perhaps wasn't as steady on his feet as he might have been.
So they discounted it by what's called contributory negligence. So $317,000 is reduced.
That's right.
By a percentage, and he got
Of significance, he got the domestic assistance, which is what we know as Griffiths and Kirkmire.
That's right.
You got $60 with a discount rate of 5%.
Yes.
Over 30 years, which gave him another $50,000.
That's right. Significant increase in his damages.
Look, I think it's getting towards that part of the show, Harry, where we've got to move on. Look, I want to thank Alice for coming on board. You've been fantastic. I think the viewers have enjoyed you.
Thanks very much, Tony. Thanks, Harry.
great contribution.
It's been a pleasure being on the show.
Dare I say, an up-and-coming lawyer. Julia Gillard's Prime Minister. We never know.
Well, I've got big shoes to fill.
Yeah.
Thanks again.
Thank you.
We've got to go to a sponsors break, so please, viewers, keep watching. Don't go away. Back
Thanks
shortly.
very much.